This program is brought to you by the following proud sponsors: the National Electrical Contractors Association, Southern Sierras Chapter, providing power to America for over 100 years, and by the Inland Empire Labor Management Cooperation Committee, bringing labor and management together to help build this region's future, and by the International Brotherhood of Electrical Workers, Locals 440 and 477, supplying the skilled workforce lighting the way to America's future.
Hello and welcome to RCBN's Business Insight. I'm your host, Dwight Cromie. Our topic today is the importance of having an exit plan for you and your business. Our guest speaker is Brian Connors, a certified financial planner and investment advisor representative with NPB Financial Group, LLC, a broker-dealer. Brian has over 30 years' experience advising high net worth individuals and successful business owners and business executives on the importance of financial, tax, and investment matters having a significant financial impact on their personal and business net worth. Acting as their personal CFO, Brian has advised on broad-ranging financial planning areas including financial management, retirement planning, tax planning, estate planning, life insurance, and more. For his business clients, Brian has advised business owners and executives on financial management, 401ks, profit sharing, pension plans, ESOPs, and exit plan strategies. Welcome, Brian.
Hey, thank you, Dwight, for having me.
Again, you've been on the show before, and you've brought up quite a few projects. I think one of our last programs was how to exit your business or plan to exit your business. Today, we're going to talk about estate planning, and a lot of people don't deal with estate planning or don't really understand it, or it's such a quote boring project or subject that people avoid it.
Death is not very flattering.
But it's important for those who want to leave a legacy or want to know that their wife and their children are taken care of. And you really need to plan that. It's not something that just happens, correct?
Absolutely, and it's so important. And I've unfortunately had the experience of that with a business partner, and what can go wrong will go wrong. And when you really do think about it, the legacy that you leave beyond this earth is going to be determined by a lot what was in maybe this simple document, the estate plan. And while we don't want to talk about it, and it's kind of just that topic of, let's put it over, we can do it tomorrow, that if done properly, if nothing else, forget about the money, just family harmony is a good outcome. And when it's not done right, even if there is money, family disharmony is a result. And, so, we think more and more about, how do we protect the people we care about most? And, a lot of this is not that costly, can be done affordably. And we could do some very simple things to protect our loved ones. And yet, so often, by even very, very famous people we've heard of, they did not have a will. So while it's not a topic we prefer to talk about at the dinner table, some thought as to having something in a very, at least a simple document describing our intentions could save a lot of unfortunate disharmony among people that are surviving us. When it comes to a business, it's even, magnified even more because you have maybe potentially other people infected in the business. Right. And the business, which might, for many business owners, might be their most valuable asset. And if that goes down, not only do we lose the income generation, but we lose the value of the asset itself. And there is about something like 16% of businesses will close their doors no matter what happens. But so I think, it's important to kind of take care of our affairs. And I think for a lot of people, they think, oh, that's only what the wealthy people do. I don't have much.
Right.
But, still, whatever that is, and if nothing else, there's some concerns about how do you provide for the welfare of children.
Right.
What happens to things that if they're not, put down on paper, they're going to be locked up in maybe a thing called probate.
Correct.
So,
Well, I think it's also important, especially if you're a business owner, to make sure that your affairs are in order. I mean, it's just a part of doing business. But I think for a lot of individuals, business owners and individuals, estate planning is important, whether you have kids or not, because again, it's a part of your legacy. Are you going to give all your money to your kids? Are you going to give some of your money to kids, some to charities that were important to you? Again, if you don't have kids, what are the charities you want your money to go to? You just don't want it to go to the state.
right.
Even if it's, like you said, you're not wealthy and you only have, $100,000 to leave, or you had a will, you want to make sure it goes to where you intended
Exactly.
it. And without a plan, it's not going to.
No.
So I'm not going to go much further. I'd like you to go ahead and make your presentation, and we'll talk when you're done.
Okay, thanks,
Thank you,
Dwight.
Brian.
So let's begin. Let's talk about some of the reasons why estate planning is so important. For many business owners, it seems like they devote more time to planning a vacation or where to eat dinner than they do deciding who will inherit their estate. Very, very common. Sure, estate planning isn't fun as booking a trip or checking out a restaurant reviews, but without it, you can't choose who gets everything that you work so hard for. Estate planning isn't only for the rich, number one. Without a plan in place, there could be a long-lasting impact on your loved ones, even if you don't have a pricey home, large investment account, or valuable art to pass on. So you're not convinced that estate planning is necessary? Consider these 4 reasons why you should have an estate plan in order to avoid potentially devastating consequences. Number 1, estate planning prevents your assets from ending up with unintended beneficiaries. If estate planning was once considered something that only the wealthy needed, nowadays many middle-class families need to plan for when something happens to a family's breadwinner or breadwinners. After all, you don't have to be super rich to do well in the stock market or real estate industry, both of which produce assets that you will want to pass on to your heirs. Even if you're only leaving a second home behind, you don't decide who receives the property when you pass away. You won't have any control as to what happens to that property. That's because a main component of estate planning is designating heirs for your assets, whether it's summer home or a stock portfolio. Without an estate plan, the courts will decide who gets your assets, a process that can take years and get real ugly. After all, a court doesn't know which sibling has been responsible and which one shouldn't have free access to cash. Nor will the courts automatically rule that the surviving spouse gets everything. Number 2, protect families with young children. This is very important. Nobody thinks of dying young, but if you are the parent of a small child, you need to prepare for the unthinkable. This is where the will portion of an estate plan comes in. In order to ensure that your children are taken care of in a manner that you approve of, you'll want to name the guardians in the event that both parents die before the child turns 18. Without such a will, the courts will again step in. And this time, it's not to determine who gets a piece of real estate or artwork. It is who will raise your children. Number 3, stop heirs from overpaying in taxes. Estate planning is all about protecting your loved ones, which means in part giving them protection from a big tax hit. Essential to estate planning is transferring assets to heirs with an eye towards creating the smallest tax burden for them as possible. Even with just a little bit of estate planning, couples can reduce much or even all their federal estate taxes or state inheritance taxes, which can get very pricey. But without a plan, the amount that your heirs will owe Uncle Sam could be quite a lot. The 4th reason to consider an estate planning is estate planning eliminates family messes when you're gone. We've all heard those horror stories about when someone with money dies. The warring between the family members only begins. One sibling may think he or she deserves more than the other. Or one sibling may think that she should be in charge of the finances, even though she's notorious for racking up debt. Such squabbling can get ugly and end up in court, with family members pitted against each other. It's yet another reason why an estate plan is necessary. This will enable you to choose who controls your finances and assets if you become mentally incapacitated or after you die, and it will go a long way towards quelling any family strife and ensuring that your assets are handled in a way that you intended them to be. The bottom line, simply put, if you want your assets and your loved ones protected when you are no longer can do it, you will need an estate plan. Without one, your heirs could face huge tax burdens, and the courts could designate your assets are divided or even who gets your children. So let's talk about what is estate planning. Estate planning is a collection of preparation tasks that serve to manage an individual's asset base in the event of their incapacitation or death, including the bequest of assets to heirs and the settlement of estate taxes. Most estate plans are set up with the help of an attorney experienced in estate law. Some of the major estate planning tasks include creating a will, limiting estate taxes by setting up a trust accounts in the name of beneficiaries, establishing a guardian for living dependents, naming an executor of the estate to oversee the terms of the will, creating, updating beneficiaries on plans such as life insurance, heirs, and 401ks, setting up funeral arrangements, establishing an annual gifting plan to reduce taxable estate, setting up durable power of attorney to direct other assets and investments. So breaking it down, what is estate planning? Estate planning is an ongoing process that should be started as soon as anyone has measurable asset base. As life progresses and goals shift, the estate plan should move to be in line with your new goals. Lack of adequate estate planning can cause undue financial burdens to loved ones. Estate taxes can run higher than 40%. So at the very least, a will should be set up, even if the taxable estate is not large. Some people ask, why should I have a will? Many people believe that when they die, their personal belongings and all of their worldly possessions will automatically go to their next of kin, even if they don't have a will. Unfortunately, they're wrong. In fact, if an individual dies intestate without a will, the probate courts will determine how to distribute that person's assets. And although the court system may ultimately decide to distribute the individual's assets in a manner that is consistent with his or her wishes, there is no guarantee that this will occur. There are other downsides to the probate process and dying without a will as well. For example, it could take many weeks or months for the courts to compile an accurate list of an individual's assets. It could also take a prolonged period of time to identify and locate the potential beneficiaries. Ultimately, unfortunately, until this process is complete, money may not be distributed, even to the legitimate and known beneficiaries. I've seen this happen in real-world scenarios. By drafting a will, an individual ensures that his or her belongings will go to the desired beneficiaries. In addition, although some states may still provide probate review wills for validity, the existence of a will can speed up the court review process considerably. We will go over the major benefits of drafting a will. Wills can limit family disputes. Courts will allow wills to be contested in very rare circumstances. This usually occurs when there is reason to believe that the will is not totally legitimate. For example, if a person making the will is not of sound mind at the time the will is drafted and was influenced by some opportunistic third party, that's a problem. Although there is no guarantee that a relative won't contest a will or sue to obtain assets not bequeathed to them in the document, a well-written will can limit family arguments. You should be specific. The key to being specific as possible when leaving an asset to a relative. For example, rather than including statements such as, "I leave my rare coin collection to my cousin Jack," such a provision should read, "I give my entire rare coin collection, which consists of an 1812 United States penny and one 1810 American $1 bill, to my cousin Jack F. Kennedy, 100 Main Street, Anywhere, USA, 12345, zip code. Again, the idea is to provide as many details as possible about the assets and the person that should receive the property. Specificity can prevent fighting, so to try to lay out your wishes as explicitly as possible. If you leave a valuable asset to a member of your family, create a follow-up provision stating who will be next in line to receive this asset if your chosen beneficiary dies before you do. I've seen this happen, unfortunately. Or the person is unable to accept the inheritance. Naming a contingent beneficiary is recommended because it will prevent family fights who should be the initial beneficiary being unable to accept the gift. Wills can outline personal preferences and desires. In addition to bequeathing assets to beneficiaries, a grantor, the deceased in this case, may also outline how he or she would like certain assets to be used in the future. For example, a provision might say something like, I give my antique 1938 Ford automobile to my son Jeffrey Smith at 123 Oak Street, Anywhere, USA, zip code 12345. I hope that my son will sell this asset to pay for his education or for a down payment on a new home. Well, to be clear, such a stipulation is not legally binding. In other words, the son would not be legally mandated to sell the vehicle. However, it is considered by some to be a great venue for an individual to convey his or final wishes in simple terms of both family members and beneficiaries. These type of provisions may also prove to be extremely valuable to beneficiaries and executors who might otherwise be unprepared to handle the administration of an estate. Wills make quantifying and distributing assets easier. Without a will, a probate court might send out letters of inquiry to local banks, brokerage firms, and other financial institutions to get a better handle on the deceased's financial situation. In addition, relatives may be asked to produce financial paperwork such as brokerage statements, doc certificates, government bonds, or other similar documents. The logic behind these efforts is that the court first needs to know all of the assets that exist or that already existed, so that they may distribute them in an equitable manner. A will prevents the need for all the footwork and paperwork because it formally outlines the deceased assets. It may also quantify what certain assets are worth. What happens if a certain asset isn't identified by name in a will? How will it be distributed then? In order to provide for that contingency, the will may contain a clause indicating that any remaining assets not previously distributed elsewhere shall be paid to my mother, Jennifer Smith, at 456 Main Street, Anywhere, USA, zip code 56789. But such a provision will help to ensure that all individuals' remaining assets, such as assets acquired after the will was drafted, will be distributed. Incidentally, without a will, a court will decide what happens to the assets. Another reason for a will is wills can name a guardian for your children. Without a will, the state which you reside will determine who will retain guardianship over your children. While the state might choose someone you approve of, such as a family member, they may also choose an institution or an unrelated party. Not a good outcome. To avoid this, a will may outline a guardian of your choosing. To parents with young children, this is an invaluable provision that mustn't be overlooked. Another reason for having a will is to provide for your heirs with special needs. Suppose that one of your deceased beneficiaries is either too young or too immature to manage their inheritance. In such cases, a will may, by provision, place these assets in another vehicle known as a trust upon your death for the benefit of that individual. Stipulations can then be put in place within the trust which limit when and under which conditions the individual can access the inheritance. For example, a provision might provide for distribution of the assets when the beneficiary reaches the age 25, or it might allow for the distribution of monies over a period of time. The logic behind such a provision is that the beneficiary will become more financially savvy and more mature over time. Incidentally, Provisions may be tailored to care for elderly family members or those with special needs as well. Bottom line, individuals seeking to prevent family infighting and who want to ensure that their spouses, children, and other relatives are properly taken care of after they die would be wise to consider drafting a will. Due to the very legal nature of a will, be sure to consult an attorney prior to drafting and executing the document. An attorney will tailor a plan specific to your circumstances. So you've worked hard your whole life to build your savings, and after all is said and done, you want to pass your estate down to your heirs. However, if you're not careful, this process can go painfully wrong. Fees, taxes, legal costs can set you back, and it's possible that your heirs don't receive what you intended. Fortunately, this can be avoided, and the steps to take care of this are simple. So let's talk about what is the benefit of having a living trust or a simple will. So the question becomes to will or not to will. Here is the easiest way to remember a will versus a living trust. A will directs the disposition of your assets after death, while a living trust becomes valid while you're alive. For many years, a will has been the popular choice. When someone leaves his estate to the next generations in a book or a movie, it's always done via a will. In reality, a will isn't likely to be the best option for most people. A will involves a probate process, unfortunately, which comes with unnecessary costs. However, when you use a living trust, the upfront cost might be higher, but you have no probate is required, which makes it a more affordable option overall. There is one exception. Some states offer expedited and simplified probate if the estate is under a specific dollar threshold. The dollar threshold, of course, depends on the state. Aside from that exception, you should strongly consider a living trust opposed to a will, and perhaps you probably should have both. So what are the basic living trust advantages? A living trust becomes valid immediately after you execute the documents and your property is transferred into that trust. It's important that you transfer them to the trust. That, however, is up to you to manage those assets, and if you're an investor, then you can look at them as a form of active management versus passive management. Only in this case, active management is more affordable. In addition to affordability, which stems from avoiding the probate process, a living trust will allow you to control what happens to your assets during and after your death. Also, unlike a will, a living trust is not a public record, very important if you want to keep things private. Furthermore, you can use a living trust regardless of the size of your estate. Other pluses of a living trust include federal and state tax advantages, a better chance of withstanding the estate being contested, and the ability to determine when a small child, grandchild, or special needs dependent will be able to access to the trust. A living trust is a much faster and easier process than a will, and it is more specific than a power of attorney on a will. As long as a trust is funded, the freezing of assets will not be allowed. Be sure to have all assets titled in your trust's name, of course. That includes certificates of deposit, CDs, stocks, bonds, mutual funds, real estate, businesses, etc. This will help you avoid probate. You know, a lot of estate planning lawyers have paid for their luxurious lifestyles by leading clients down the wrong path, which is probate. If you challenge one of these estate planning lawyers on this topic, he or she might state that a living trust is more expensive. But that's only the case up front. A living trust is almost always a cheaper option when looking at these two options, will versus living trust, in terms of their total entireties. So what about the beneficiaries? Do you have a child from a previous marriage that you would like to treat as a beneficiary? If so, it would be wise to consider a living trust. If you use a beneficiary design or joint ownership, your spouse could end up with control of your assets, which could then lead to those assets going elsewhere, including their children from a previous marriage or even a new spouse. Your children can be in charge of their own shares. As a trustee, your children can invest however they see fit. They will also have the option of taking out money from the estate for living expenses. And they can use it to help pay for their child's education. Your child's inheritance will be protected, not only from creditors, but bankruptcy as well. If you were to choose a will, the above available options wouldn't be available. Let's talk about retirement funds. Be sure to hire an experienced attorney. Not only should that help you avoid the above scenario, but it should help you determine who receives your individual retirement account, IRA, 401k, or life insurance. The recipient of your retirement accounts and your life insurance policy is based on the beneficiary on the account of the policy, not the name on your trust or will. A specifically designed trust can help you avoid this scenario. Some new trends. Baby boomers are hopping on the living trust bandwagon, and for good reason. Avoiding probate is the biggest advantage, but as you already know, based on the information above, it's not the only one. There are other things you should know about a living trust prior to making an important decision. A living trust is revocable while you're alive, but irrevocable when you're dead. There are 3 parts to a living trust: the creator, the trustee who manages the assets, and the beneficiary. Strongly consider naming yourself as a trustee for control of your assets. A living trust can be used as a substitute for a power of attorney. You can determine when assets are passed on to a beneficiary. It doesn't need to be immediately upon your death. A disgruntled heir has the ability to challenge a trust, of course. A disgruntled heir can also challenge a will. You can also fund a living trust at your desired pace. Always hire an attorney to prepare a living trust. Avoid a horror story, which are many. Avoid online living trust kits. The average living trust will cost a few $1,000s to set up, but in the scheme of things, that may not be a lot. It may be actually very cost effective. The bottom line, for most people, a living trust will present a faster and more affordable option than a will. There are numerous advantages to a living trust, with the most important being avoiding probate. However, this doesn't undervalue the other advantages above, which include avoiding assets moving to an unintended direction. Let's talk a little bit about business continuity planning, since many of you might own a business. What is a business continuity plan? A business continuity plan is an emergency plan that assures a seamless transfer of control and responsibility in the event of a sudden departure from the practice by choice or through termination of employment, death, or disability. A continuity plan should result in a formal written continuity agreement. For some, the first and only solution is to purchase a life insurance policy, perhaps a buy and sell policy. The secondary solution is a revenue sharing agreement. What should a formal business plan, continuity plan, formal agreement include? Well, number 1, determine a trigger event: death, disability, loss of a license, etc. Number 2, what is the formula for valuation? 1-to-1, 2-to-1, diminishing practice, change of industry? Number 3, what are the reasonable payment terms, lump sum, or period of time? And number 4, determine who the buyer will be, if it's a culture fit or a business fit. The bottom line, simply put, if you want your assets and your loved ones protected when you no longer can do it, you will need an estate plan. Without one, your heirs could face huge tax burdens, and the courts could designate how your business and other assets are divided, or who even gets your children. We hope this estate planning information roadmap has been helpful to you towards starting the estate planning process today. Remember, the most important legacy that you perhaps will ever leave to others is a written document known as your estate plan. Your family's financial security and family harmony may be more determined by the estate plan you put in place for their welfare than just about any other accomplishment you may have ever achieved. Likewise, your business succession plan may perhaps be the most significant financial decision regarding perhaps one of your most valuable assets in determining a continuation of your family's welfare, but also your business legacy with those you have chosen to continue with business on. So start your estate planning today with your end game in mind.
Well, Brian, having an estate plan is kind of like having life insurance. I mean, I'm sure there's a lot of husbands and wives who really care about their family, who've spent the time and invested in life insurance or their whole life or term to make sure that their family's taken care of. But without having a will or a living trust, it's like you've only gone halfway.
Right. So first couple of things, you're right. Talking about life insurance, estate planning is not the preferable, dinner topic of choice. But what many people don't know that if we talk about life insurance, for example, there's many uses for life insurance. One is obviously to plan for our unforeseen demise. But there is different types of life insurance depending upon what you're trying to do. And while I'm careful to say you might consider the use as a part of your retirement plan, there are some features that could be usable if necessary in terms of what we call cash value buildup. That could be potentially taken out if necessary or used for other purposes. One might be even long-term care. There's policies that have those kind of riders today that can allow the death benefit to be used for providing long-term care benefits. Likewise with an estate plan. Most of it we think about the distribution of our assets after we're gone. But there are some things in estate planning that can be useful for tax planning in terms of like charitable trust, in a way that you might be able to sell a very high gain, high appreciation asset like real estate or a very high valued stock without having to pay the capital gain and put it into a charitable trust and then live off the income from that trust for the rest of your life at a nice payout, assuming there's assets to do that. So there are some proactive ways. There's also ways to diminish the taxable value of a transfer of an asset. There's a term called minority interest and things like that in estate planning, especially as it applies to a business, and a way to reduce the value of that asset for estate planning tax purposes. So, and there's other things in terms of installment sale planning and other overall tax planning. And the importance of this is that while you're living, there are income and estate tax consequences in how you do things. And particularly with a business, as we're talking about in many cases, it's really important to consider both the income tax consequences and the estate tax consequences in what you're doing in terms of the way that you might sell your business. Whether it's an S Corp or C Corp, they have dramatic differences in terms of what might be the net value of that asset to you. We've heard of situations where while someone was going to sell a $10 million asset business or $20 million, the net to them was quite substantially less after taxes. So tax planning is important, and it's important to look at it from multiple points of view, both income tax and estate planning. On the estate planning, again, it's those unintended consequences that could really disrupt a family's welfare, particularly your loved ones. And if you're a business owner with young children or a spouse that's depending upon income from this business, not having this thing properly structured with a thought-out estate plan could be very costly in terms of the transfer of that asset ultimately to the beneficiaries. So I think it's very important in terms of the overall plan or financial plan of what you're doing both during your lifetime, but also considering post your lifetime in terms of what's the net benefit going to be to the people I care about most. And that's really where it gets personal. I think most of us think about in terms of our livelihoods and who cares when we're gone. Right. But there are a group of us, I think, out there that are saying, it is very important to me to make sure that I take care of my loved ones. And personally, in my own situation, being healthy, still currently healthy, I've taken the time in the last year to reevaluate all those things, because there is a period of time where, particularly for insurability reasons, you can get certain types of insurance affordable. And there's certain times where you may not be able to get insurance if you wanted it. For example, like a buy-sell agreement with a partner to transfer the business in case something goes wrong. You need to think about that, not like when you're in your 70s when you're saying, I only got 2 years and I'm going to retire. But for business owners in their 50s, they really need to be thinking about some of these things, because while you may not want to sell your business immediately, if something does happen between that time and the time you do decide to sell, in terms of incapacitation, disability, or death, the business might go under because there isn't enough money to transfer what the value of that asset to the surviving beneficiaries. The other problem that I see sometimes, that's talked about a lot in estate planning, is for people that own a large part of their business is in an asset. Maybe it's in a building or it's in raw land, like a farm. I mean, some families have been really dramatically hurt because they could not come up with the money to pay the estate taxes on that. So having a plan to, to provide resources, life insurance assets and other things like that, that you can take care of the estate tax bill is important if your estate is significant. So I always advise, people when they talk to me about, whether they need financial advice, tax advice, or estate planning advice, what should they do? I said, the interesting thing about it is the cost of no advice is potentially so much more expensive than the cost of advice. Right. So it's important to at least get some advice about what you should or not do from a competent person so you can make an informed decision as to what you actually should do.
The takeaways I got from your presentation are, one, don't do it yourself. Make sure you bring in a competent attorney and the one that does believe in trust, not just wills. Secondly, it's not just a process where you bring in your attorney. You do want to bring in your financial advisor to work with your attorney to help you develop the right, I will say, exit strategy, in a sense, for your possible death. But those are the things I think people should do. But the biggest walkaway is you need to do it.
You need to do it. You need to have something, and it can be done affordably for most people without too much money. If you really care about your siblings and your loved ones and your beneficiaries and your spouse, it's perhaps the biggest legacy you're going to leave as to what happens after you're gone. And while we don't always think of that potential ramifications, I've seen it in my professional capacity happen unexpectedly, that things which were unintended are now a problem. And unfortunately, the wrong result happens more often than we like to think about it. And this creates, family disharmony at the worst possible, situation where family members, brothers and sisters that once got along no longer get along. And I've seen it happen personally in my family, and I've seen it happen elsewhere. So, whether it's a ring, it's some kind of, heirloom or something that you're passing down. You really want to think about that and make sure you have something basic in place. The other is for funeral arrangements and some other things. How do you want to be disposed of? These are personal things, and I think there's a lot of personal things that we forget about. We say, well, it doesn't matter, I'm gone, right? Yeah, technically it does matter because, how you're remembered is important to those people. I know you probably can think back about your parents and what you think about them in terms of, how you were raised and right. What they did for you. And maybe if it wasn't even that much, it was just whatever legacy they left you with. Right. I think it just take a different attitude about it. And this comes back to the business and to the way we look at things. Start running your life in a more organized manner. You'll have a better life. You'll probably have less potential disasters to befall you, especially financial disasters, right. If you have competent advice. And I call those key advisors you may want to have as part of your team, or at least have that relationship. You should have a financial advisor. You should have a CPA or tax advisor. You needed an attorney of some kind as a very minimum, potentially an estate planning attorney, insurance broker or agent, and you might need a banker if you're in business. And these are your team that can hopefully, if nothing else, help you avoid the pitfalls. And it's always those unintended consequences that seem to be very costly. There's so many examples. But just another one came up, for a business owner, for example. Not having enough insurance. that something happened with one of their employees that through no fault of the business owner is going to cost the business owner money in terms of a lawsuit. Well, if they just paid a little bit more in insurance, it wouldn't have mattered.
Right.
It would be insignificant. And so getting that expertise to come and help you, which is all important in everything we talked about in exit planning and estate planning, business planning, is going to help you go farther. And you look at the people that have the biggest wealth, they all have that team. And if you look at athletes on another level, what do they have? They have coaches, right? You can look at almost any athlete that we know of, and look behind the athlete, and you'll probably find a top-tier coach. And so think about it that way, that this is part of your team in life to help you make more informed decisions. And that comes in any area that you have lack of knowledge in. And I think you'll find that in the long run, it's less costly, and you actually get more opportunity as a result of that.
One thing before we close that I also thought was an important takeaway, kind of like when you're talking about exit planning with a business, you want to have the end game in mind. Wills are not for people who are older. I think probably the second you have assets, but probably the most important thing that young people, young families should be considered the importance of a will or a living trust once they have kids.
Yes.
It's not something that you think, well, I'm 30 years old, I'm young and I'm healthy, I don't have to worry about a will until I'm 40 or 50 or 60 years old. Once you have children, mm-hmm. you really need to have a will. Would you agree that that's...
Absolutely. It's a very minimum because, like you said, if you have young children and you pass away, you might have passed on the decision of who's the guardian to a court, to the state. The last person you probably ever considered as a potential person to be the guardian for your child. I mean, it's disastrous. That's why you have foster homes and these other things. Some of this could have been decided beforehand, or should have been decided beforehand. But yes, once you have children, you should definitely have a will. And you should probably also be considering, if you have any kind of assets at all, a home, a trust. Example, someone near and dear close to my family, we tried to get them to get a trust. They had a will. Unfortunately, they did not get the trust established in time, and it got caught up in probate. Well, that happened to be during the Great Recession of 2007, 2008. The asset dropped from $500,000 to $250,000 in literally a year and a half. By the time they sold it, they basically ended up $250,000 less than they could have had it if they had a trust. If they had a trust, the successor trustee would have been defined already. It would have just passed over theoretically to the children or to the beneficiaries, whoever they decided they wanted to be the trustees. The property would have retained it within the trust. It would have been living in this case. It's a live document. And then the new trustees would be able to decide what they want to do with the asset. If they wanted to sell it right away, they could. But because they were tied up in probate for a year, the asset lost value and then subsequently cost them a lot of money. Same thing can happen with a business. If you have a will just for your business, if you have anything worth anything, it's possible, most likely going to go into probate because it's more likely than not that there's liabilities attached to that business that have to be settled. And so, again, a trust, a business continuity plan, making sure that you know what should happen, how this business could be transferred to someone else. Again, I have personal experience in this situation, unfortunately, but having a business continuity plan, the spouse now is protected. Without it, the business would have had no value to the surviving spouse, which is a disaster with young children. And so, if you have a legitimate business that is making some money, that has some transferable value, you really need to think about that continuity. And it could be it doesn't have to be, this long, big old, something in place, 3 or 4 pages describing the valuation, the trigger events, these kind of things, and then finding someone that says, maybe competent enough to take the business, or at least to find someone that could continue the business. But the cost of no planning is very expensive. I've seen it over and over again, tragically so. And I would just advise people to say, hey, think of it as a proactive thing. Look most importantly about the things you care about. And if you care about your loved ones and your family, take the action of getting at least a will and a trust. And if you own a business, also factor that in terms of a business continuity plan,
Right.
et cetera.
Well, thank you, Brian. I appreciate your insight today.
Thank
and we
you,
look
Dwight.
forward to seeing you back here.
Thank you very much.
This program is brought to you by the following proud sponsors: the National Electrical Contractors Association, Southern Sierras Chapter, providing power to America for over 100 years, and by the Inland Empire Labor Management Cooperation Committee, bringing labor and management together to help build this region's future, and by the International Brotherhood of Electrical Workers, Locals 440 and 477, supplying the skilled workforce lighting the way to America's future.